The most important Supreme Court case nobody's talking about involves copyright law. It's Cox Communications versus Sony Music Entertainment. I'm Jim Gibson, and I'm on the faculty at the University of Richmond School of Law, and this is the Synopsis. Alright, here's what's going on. Suppose someone uploads an episode of, say, The Great British Bake Off to YouTube without the copyright owner's permission. The copyright owner can then send a notice to YouTube asking them to take the video down. If YouTube doesn't comply, then YouTube is liable for copyright infringement. Now, it's important to note that YouTube is not immediately liable as soon as the episode is on the system. Instead, we impose liability only if YouTube receives notice of the video and then fails to take it down. This is called the notice and takedown approach to online copyright infringement, and it's been around for some 30 years. The idea is that the law creates an incentive for online platforms like YouTube, which host content put there by third parties, to take infringing content down. So imposing liability on YouTube doesn't make any sense if they don't know the content is up there in the first place. You can't do anything about infringement if you don't know the infringement is taking place. It's notice, then takedown. Well, now let's consider another type of online company, Internet Service Providers, or ISPs. And ISPs are very different from platforms like YouTube, because ISPs don't host or store any content, they just provide the pipes through which data travels. And they have no idea what data is traveling through their pipes. It could be an infringing copy of The Great British Bake Off, or it could be an email to grandma. The ISP has no idea. So if a copyright owner sends a notice to an ISP that one of its customers has uploaded an episode of The Great British Bake Off, there's nothing the ISP can do about it. Nothing to take down. The file is out of its system by the time the ISP learns about it. You can't do anything about infringement you don't know about until it's too late. Nevertheless, over the last few years, some courts have imposed liability on ISPs because they've been told after the fact that some of their customers committed copyright infringement using the ISP's pipes. And because there's no infringing content for the ISP to do anything about, remember it's out of the system by then, what the copyright owners have demanded is that the ISP cancel the customer's account entirely, which means anyone who uses that account, the infringing customer, his roommates, his family, maybe the whole apartment building if they all share the same Wi-Fi, can't get on the internet. This is not notice and takedown, this is notice and shutdown, and it's nonsense. It's one thing to make YouTube take down an infringing video that's residing on its system. It's another thing entirely to make an ISP deny internet access to an entire account because of some past infringement it couldn't have done anything about at the time anyway. And it's not like the account was only used to infringe. Even, online infringers use internet access for plenty of legitimate purposes, including vital things like remote employment or schoolwork or emailing grandma. Internet access is not a luxury, it's essential to modern living, like electricity or water. Now, if copyright owners want to send a subpoena to an ISP saying we know that this account has been used to infringe copyright and we'd like to know who owns this account, well, that's fine. Then the copyright owners can sue the infringers directly and the ISP sort of gets out of the way. But telling an ISP to shut down internet access for infringement that it couldn't do anything about is something copyright law has never done, even though people have been using internet access to infringe copyright for decades. And it shouldn't be done now. Fortunately, the Supreme Court has taken up Cox Communications versus Sony Music Entertainment. I'm one of many legal experts who have filed briefs in this case, urging the court to reverse this really troubling trend. We should get a ruling in spring 2026, and here's hoping the court does the smart thing and shuts down notice and shutdown.